Hello Michigan Realtors, I'm Brian Westron and welcome back to the Letter of the Law. This segment will address the legalities of using home surveillance systems during open houses and home showings. In today's age of progressing technology, it is not uncommon for homeowners to implement the use of nanny cams or other digital surveillance systems within their homes. While the practice is not uncommon, it does pose various legal concerns when homeowners use these devices to record interactions between potential buyers and their agents as they tour an open house or a private showing. Many realtors would argue that the seller should have the right to monitor their homes during showings in order to protect their property. Other realtors would argue that it is wrong to secretly monitor persons who believe that they are having a private conversation about a major life decision. Either way, it's important that realtors fully understand the legal implications of using audio and visual recording devices during home showings so that they can educate their clients. Surveillance laws vary from state to state. However, in general, video monitoring is prohibited in places where someone has a reasonable expectation of privacy. With audio surveillance, on the other hand, most states require the consent of all participants or at least one participant in the conversation that is being recorded. Now, states vary whether this limitation applies without regard to whether the speaker had a reasonable expectation of privacy or not. In some states, the legality of surveilling potential buyers, video and audio, requires advance notice of the use of the surveillance equipment, such as the posting of a sign to the effect that surveillance equipment is in use. In other states, notice is not required to videotape, but notice is required to record. Now in Michigan, the Penal Code prohibits the installation, placement, or use in any private place of any device for recording, transmitting, photographing, or eavesdropping upon the sounds or events in that place, unless consented to by all persons entitled to privacy in that place. Now, Michigan law defines private place as a place where one has a reasonable expectation of privacy. Now, many would argue that potential buyers would not have a reasonable expectation of privacy in someone else's home. It would appear, however, that we do not even need to reach this issue because the statute goes on to expressly provide that this particular statutory prohibition does not prohibit security monitoring in a residence if conducted by or at the direction of the owners of that residence unless conducted for lewd or lascivious purposes. Thus, it would appear clear that this section of the statute does not prohibit a seller from using video recording to monitor their home during showings. However, this is not the end of the analysis. A separate section of the Michigan Penal Code prohibits using a device to eavesdrop on a private conversation unless the parties consent. Now, eavesdrop is clearly defined by statute and means to overhear, record, amplify, or transmit any part of the private discourse of others without the permission of all persons engaged in the discourse. Now, the Michigan courts have reviewed this definition and concluded that because the law speaks to the private discourse of others, it is not illegal to audio record a conversation if at least one of the parties to the conversation consents. Under this section of the Penal Code, it would appear that a seller cannot audio record a showing in their home without the consent of the attendees. Now keep in mind that this statutory provision requires consent and not just disclosure of the fact that the home has been audio surveyed. As a best practice, buyer's agents should instruct their buyer clients to always act as if they're being recorded when touring a seller's home and to conduct themselves accordingly. Buyers should be warned to exercise caution when speaking to their agents or others while inside the seller's home, especially if the conversation discloses confidential information or reveals anything else that they wouldn't want the seller to know. In addition, listing agents are encouraged to caution their seller clients who wish to use surveillance devices during an open house or private showing. Listing realtors should advise their seller clients that it is illegal to use audio eavesdropping devices during a showing. Sellers should be further advised that while Michigan law generally permits video surveillance of one's own home for security purposes without disclosure, the safer course may be to disclose the existence of the video device either through posting or in the comments section of the MLS listing. While perhaps not legally required, disclosure appears to have no downside, and it may in fact be a good idea for sellers to encourage buyers to act as if someone is watching when they tour their home. As always, thank you for tuning in and watching this installment of The Letter of the Law. If you like our video series format, be sure to check out CE On Demand by clicking the link above. The Letter of the Law format has been expanded into various continuing education offerings that you can take easily in the comfort of your home or office. If you have questions or would like to suggest topics for future videos, please send those suggestions to the email below. Your question might even be featured on our new legal Q&A series, From the Mailbag. Again, thanks for watching, and see you next time.